Hello everyone, I'm Andrew Lowe. I'm a senior caseworker of the National Crime Applications team based in Nottingham. I've been with Legal Aid for 4 years and I've been a senior caseworker for nearly 2 years. Today I'll be talking about the 5 most common reject reasons that we've seen between January and March this year, what we're looking for when we process an application, and some of the ways that you can make sure that we are able to process your application on the first submission. So between January and March, we processed 72,664 applications and rejected 7,194, giving us a 9.9% reject rate. We are aiming to reduce these, and there are several initiatives on our side that we are implementing that we expect to begin to have a positive effect later this year. We are also continuing with these webinars. So we group rejects into one of 4 categories, and these can be seen on slide 6 of your information pack, along with the percentage of applications that were rejected that fall into each category. As you can see, clarification required is by far the most common reject category, and evidence, issue, and duplicate application are second and third with 21 and 22% respectively. Breaking this down further, we have found that 43% of rejects relate to income, benefits, or savings. Duplicate applications from the same or a different provider are 13%, co-defendants represented by another firm 11%, and either way offences applied for but summary only selected are 7%, with CRM 15 needed down at 6%. National insurance numbers dropped out of the top 5 for the first time in years at 4.5%, which we believe shows that these webinars are having a positive effect. However, we still feel that we can reduce it even further, so we have still included a section on when NINOs are or are not required. I would also like to make clear at this stage that the means assessment rules for processing applications that have been committed to Crown Court for sentence are the same as in Magistrates Court. So when we refer to the Magistrates Court, we are also referring to committals for sentence. So straight into national insurance numbers. We will require a national insurance number for all passported benefits cases, including universal credit, which should be entered as a guaranteed state pension credit. This is a workaround until universal credit can be added to the list of passported benefits. We will not accept dummy national insurance numbers such as AA 123456A, and the e-form will not require you to enter one to submit the application. However, as just said, if we do need it and you haven't put it, then it will be rejected back to you. The only exception to this rule is if your client is remanded in court custody, and we can verify this with HMCTS. If they are in police custody, we would still require their national insurance number. We will also require the national insurance number if the case is sent to Crown Court for trial. However, we will issue an income evidence request to obtain this. So if the case is indictable or trial already in Crown Court, you can submit the application without the NINO. Just be aware that if they receive passported benefits, we will need a national insurance number, regardless of whether the case is in the Crown or the Magistrates Court. On slide 10, you will find a table detailing all of the scenarios where a national insurance number will or will not be required. So moving on to the 5th most common reject reason, CRM 15 required. This occurs when the application declares less than £12,475 per year. However, the evidence provided shows a gross and/or year-to-date income greater than that amount. We are unable to complete an assessment because when a CRM 14 is submitted instead of a CRM 15, we do not have all the details we need to complete a full assessment, including the outgoings and capital information. You can avoid having an application rejected for this reason by using the gross income instead of the net income when declaring it on the application. It is also worth checking that the year-to-date is not significantly higher than that month's gross income. We will always use the most recent wage slip that is prior to the date stamp. This is because the means assessment represents their income at the time that legal aid is being considered. If wage slips that post-date the date stamp show a lower income, then they should be submitted as a change in financial circumstances after the original application has been processed and will be considered on a case-by-case basis. We will use the year-to-date on a wage slip when the monthly average is more than 10% higher than the gross income. For example, if the gross income is £1,000 in month 5 and the year-to-date income is £6,000, the monthly year-to-date would be 6,000 divided by 5 equals 1,200, which is more than 10% greater than 1,000. Please note that if the applicant has multiple sources of income, we will total them all to calculate their total gross income, and it is this total that we will use to determine whether a CRM 15 is required.
Hello there, my name's Danis Blanchard. I currently work in the training team in the Legal Aid Agency. I've been here since end of last year. Before that, I spent 6 years processing criminal applications and a couple of years as a senior technical caseworker with a special interest in reducing rejects of crime applications. So like Andrew, today I'm going to be talking about how to reduce the most common causes of e-forms being rejected. So the fourth most common reason for e-forms being rejected is when either way offences have been applied for, but the summary only case type on the application has been selected. So when offences applied for are not summary only, more information is needed on the e-form. Please ensure that you select the correct case type on the application to avoid it looking like a duplicate, and only select the summary only case type if there are definitely no either way or indictable offences being applied for. As a tip, we'd recommend that you always select the either way case type on the e-form if there are any theft or criminal damage offences, even if the court has already indicated they'll be dealt with summarily. The reason for this is that we need to match our legal aid system to the case type on the court system. Theft and criminal damage offences are indicated as either way on the court system, therefore we need to treat them accordingly. Specific care should also be taken with changes in financial circumstances applications and appeals to Crown Court. Please do not submit a change in financial circumstances application until the initial application has been processed. So if there's outstanding evidence or information required on your initial application for legal aid, please don't submit your change in financial circumstances application until those have been resolved and all information or evidence has been provided. If you're submitting a change in financial circumstances application, please fully explain exactly what has changed. If paying privately will cause your client hardship, please ask us to consider expenditure that's not already been taken into account, such as debts and loans and the likely costs of case. You can do this by emailing CRM 16 hardship application form to National Crime Team at justice.gov.uk. If an application omits information, for example, you forgot to tell us about childcare costs, you can do one of the following: amend, sign and date the printout of the financial assessment, email the omitted information to birminghamcat at justice.gov.uk, or you can provide a new CRM 14 e-form with an explanation that you're providing omitted information so that it's distinguished by the caseworker from being a duplicate application. Please note that if you've omitted to tell us about income or outgoings, then you will need to provide evidence of those. I'll now move on to talk about situations where applications are rejected because co-defendants are represented by another provider firm, but there's no mention of actual or potential conflict. This is a reason that e-forms are being rejected that we're seeing more commonly, especially since the introduction of the Common Platform computer system in the courts, because Common Platform's telling us much more frequently that there are co-defendants than we used to see under the old Libra system. So give the names of all co-defendants that you're aware of, and if you don't represent them, you must give reasons why your client requires a different representative. Co-defendants should be represented by the same solicitor unless there is or is likely to be a conflict of interest. And for more details about that, please refer to the Criminal Legal Aid Regulations of 2013 and also the Criminal Legal Aid Manual, section 3.5. I'm now going to talk about the second most common cause of e-forms being rejected, and that's duplicate applications. For some firms, this accounts for as many as 1 in 4 of their rejected e-forms. This is where right to representation has already been granted to your firm or to another provider. If your prospective client doesn't inform you that they've already successfully applied for legal aid with another firm, it's unlikely you'll be aware that you're making a duplicate application. So we are aware that there may be a limit to what you can do to identify these situations, other than perhaps asking your prospective clients, have you made an application for legal aid with another firm? Was it successful? However, please do what you can to ensure another solicitor within your firm does not already have a representation order, for example, in another department or at a different office location. So for larger provider firms, you may wish to review your system on how it's communicated or checked internally whether an application and grant has been made.
So, as mentioned, issues relating to income, benefits, or savings was our #1 reject. There are a couple of general rules that will always need to be followed for the application to be processed. We will need to know how the applicant is supporting themselves and the amount and frequency of any payments, benefits, or other income that the applicant receives. This applies even where the applicant has been remanded into court custody in the last 3 months, if they haven't been remanded for more than 3 months. We will need to know the date when they were remanded if it's been more than 3 months. So I covered the way we calculate gross and year-to-date income from wage slips earlier, so I won't dwell too much on them again here, but you can see on slide 21 of the information pack exactly what details need to be visible for us to process an application. A common issue we find with online wage slips is that the expandable sections are closed. This prevents us from seeing details that are required to conduct an accurate means assessment, and this will result in the application being returned to you if the case is still in magistrates court, or an income evidence request if it has been committed for trial. It is also important that photographs, scans, etc. are easily legible. This means that the evidence should be flat, without glare, and clear. If the wage slip has been folded, please try to flatten them out before scanning them, as sometimes there will be a shadow on some of the figures, or the fold will go through something, making it extremely difficult to determine what is actually written. If you are unable to get a good scan and some information remains obscured, you can send in confirmation of what the figures are in a separate document. When the applicant is living off savings, we will need 3 months bank statements up to but not exceeding the date stamp. We will then add up all of the outgoings and average them across the period provided. Bank statements going further back can be considered on a case-by-case basis if the 3 months up to the date stamp do not give a complete picture. However, to include the extra dates, an explanation of why they should be considered will be required. Please note that the 3 months is the minimum that we require. If you provide 2 months, the application will be rejected in magistrates court. If the applicant is living in a rented property, we would expect to see some form of income to be received to pay that rent. The nature of this income will determine whether we require evidence or not, as discussed. If they have no legitimate income or they are receiving housing benefit, we do not need to know the amounts. However, we will need an explanation of how they are paying the rent, such as I receive housing benefit or I pay my rent from illegitimate earnings. If assistance is being provided by friends or family, then we will need to know the amount and frequency of that support. If this is erratic, then an estimate of the average weekly amount will be needed. On slide 23 and 24, you will find a table listing the time frame for acceptable evidence for a variety of scenarios.